to Crime in Court. My name is Heather, and this is another update in the Delphi case. If you follow my channel, you know that I've been reading all the court documents, all the filings that have been going on, and I'm trying to keep you guys updated. So right now, this week we've had many motions going on, so I've kind of been bombarding you guys with videos. I apologize, but it just made sense to make them in, separate videos. But in this one, I'm going to bunch a couple together as well. The title, as you can see from the thumbnail, Judge Gull rules on the attorney's contempt. So we've read through the contempt hearing for contemptuous conduct for the two, and I read through it not really thinking that there was contempt, but I also believed that Judge Gull was not necessarily ruling in favor of the defendant. So whenever there would be an objection by Nick McLeland, she would say, sure. I think we read through the whole transcript, and there were only 5 objections or 5 rulings throughout the entire proceedings that she actually sided with the defense. So I wasn't sure what she was going to say as to her findings on contempt, but here we go. First up, please hit that like button. Next, I'm going to tell you about a different thing here. So just yesterday, May 1st, Judge Gull so the defendant requested a pretrial hearing. We read through that in one of my recent videos. And within that pretrial hearing, they can go over the motion in limine that the state filed, which is crazy. The state wants to eliminate any kind of defense from the defense. They would be left with nothing. So that's why, they wanted to move forward with this hearing. That's why they wanted a Franks hearing, so they could show the judge, look, this is the evidence that there's an odinous tie. But she's, I think, being threatened or in on it. So I don't think she's going to rule favorably for the defense very often. But in this case, she actually did, and I'm glad to say. So, in 2 instances, they just got a win. They got their hearing. Their pretrial hearing is now set for court May 7th at 9 a.m. without objection by the defense, who consents to the venue. So everyone agrees that they're going to be at whatever venue they're at. It was either Allen Superior Court or some other court that they were going back and forth between. Anyways, all right. So the next filing. So that was that. This was just a notice to all the attorneys that this court date has been filed. So they're going to have a hearing. The defense actually asked for an entire day. It'll be interesting to see if she reserved the entire day, because for the contemptuous conduct hearing, or no, it wasn't that one. It was a different one. She had said, I'll give you the whole day. I'm confusing cases. Was it her? Or was it Judge Bev? Maybe it might have been Judge Bev, who was like, I'll give you the whole day to argue stuff. And then she was like, you got 15 minutes. Real nice. The day of. It's like, yeah, you got 15 minutes instead of the whole day to argue your arguments that you've prepared for today. Anyways, all right. So this is actually the order or judgment of the court regarding the contemptuous conduct, allegedly. So the court, having had this matter under advisement following a hearing conducted on March 18th, 2024, and having reviewed the evidence admitted at the hearing, the court did not review any evidence that was offered but not admitted. So I didn't review anything outside of what you guys gave me. The arguments of counsel and the briefs and memorandums submitted by counsel now finds that the state proved by a preponderance of the evidence the defense counsel was sloppy, negligent, and incompetent in their handling of discovery materials. Counsel failed to properly secure evidence and discovery material in this matter. Counsel negligently allowed their discovery outline to be sent to an individual unrelated to the matter, Brandon Woodhouse, who then disseminated this information to the public. Counsel further allowed their discovery materials to be compromised by Westerman. So the thing that got disseminated was just a list of what their discovery items were, an outline, a list. So they didn't get any information, really. All right. Counsel further allowed their discovery materials to be compromised by Westerman. That's the one who took pictures in the office of attorney Andrew Baldwin. Where was I? So counsel failed to properly secure evidence. Counsel negligently sent it to Brandon Woodhouse and was compromised by Westerman, who in turn provided the information to Fortson and Cohen. So defense let their discovery materials be compromised by this Westerman person, and Westerman then sent it off into more directions. Counsel was, and Fortson is the one who had taken his own life in we don't know why. I don't know why. I don't know if we do have a reason why, but I do believe that it was like just after a detective came and talked to him, and then the very next day or a couple days after, he took his own life. After some detective started talking to him about the pictures leaked. So counsel has described Westerman both as a criminal and a valued consultant and confidant. So Westerman, the one who took the pictures and gave them to Fortson, the one who took his own life, and then Cohen. Westerman, according to the defense, she's saying he's both a criminal and a consultant and confidant. Well, he was a consultant and a confidant until he betrayed Andrew Baldwin's trust and criminally took pictures. I mean, so yeah, he is those things, but that doesn't make it not accurate. Like, you can be both, and that's okay. I mean, it's not okay to be a criminal, but I mean, you can have dual personalities. You can be hot-headed and also loving and nurturing at the same time. You know, like, you can, everybody is has ability, well, not everybody. People who have control over their emotions, usually. All right, so counsel has described Westerman as a criminal or a confidant, and a confidant. So despite this court's findings of sloppiness, negligence, and incompetence, she has to give him a verbal beatdown. The state is required to prove that counsel's conduct was willful and intentional beyond a reasonable doubt for the court to find counsel in contempt. As the state has not met that burden, the court declines to find them in contempt of court for violating the protective order issued February 17th, 2023 regarding discovery. What's that date? When is that date coming in? February 17th, 2023 regarding discovery. I don't know. I don't know that, like, all the other dates have been, it was December 1st when the defense put out the press release, but it was the 2nd when the gag order, I'm going to read it now, so never mind. All right, so the state has also alleged that defense counsel violated the gag order issued by the court on December 2nd, 2022. Then defense counsel issued a press release on December 1st. So they did not violate a gag order that came the next day. 2 different days, and one preceded the other. So the release contained statements that are potentially violative of the rules of professional conduct. Says who? Who are you to say? I don't know. I mean, okay, she's a judge, but whatever. Like, I'm finding her actions and her rulings contemptuous and not fair. So I don't know, but whatever. A defense counsel's counsel correctly argues in his post-hearing brief a gag order was not yet issued. As such, the court declines to find counsel in contempt of court as no order was in place. To the extent that the press release violated the rules of professional responsibility, the trial court has no jurisdiction to enforce those rules. As required by the rules of professional responsibility, the trial court will, therefore, send a copy of this order and a press release to the Office of Judicial and Attorney Regulation Executive Director Adrian Meering for that office to enforce the rules or determine counsel's ethical misconduct. So she finds no misconduct, but she's forwarding on their press release, which we read in another video. I just want to see. I want to pull up the press release real quick. Sorry, I'm opening a folder. Everything always pops up on my second screen, which is the one I'm mirroring from on my Streamlabs, so it's annoying. But the press release was not, I don't think, violative of professional rules of conduct. Let's look up while we're here. Do I have the... I should have this. I just want to look at the press release real quick. No, we're not going to read the whole thing, but I wanted to read some of it. If I can find it. And then we'll look up the rules of professional conduct. I don't think I have it. So annoying. All right. I could have sworn it was here. Maybe it's in a different folder. Hold on. Bear with me. What does it say? So she's sending the press release to, what is it? The Office of Judicial and Attorney Regulation, Executive Director Adrian Meering. So they're gonna find out. I mean, seriously, they've had like unblemished records so far, and no one's ever questioned their ethics or their integrity, Rosie or Baldwin, before. But now they have this tarnishment on their, what's that word? I don't know. It's their reputation is tarnished now because of this whole thing that was really just a waste of time. I can't find the press release. I had it too. I don't know where it was. All right, so I'll do that in a separate video. I'll go over the press release and the Indiana Code whatever in a separate video just because of time and whatnot. I wanted to get this video. I don't have the press release ready, and I wanted to get this video done rather quick, just so you guys can get back to your day. All right, so the next one is the motion to enter stipulated protective order. This is well, I'll read it. This just came through, so I wanted to add it to today's video, so you kind of get a bonus, even though this was really mostly on Judge Gull's rulings. We're going to talk about, or I'm going to read through this too, which isn't very long. All right, so the motion to enter stipulated protective order. The Indiana Department of Correction, a non-party by counsel, and Richard Allen by counsel, respectfully submit these terms to the court and request the court to enter a protective order adopting its stipulations. Background. Number 1, on April 15th, 2024, Richard Allen served a subpoena duces tecum on the Indiana Department of Correction seeking certain employment information. Number 2, the Indiana Department of Correction and Richard Allen by counsel have agreed to narrow the request in the subpoena. Number 3, the Department of Correction seeks both to comply with the request and to protect itself from annoyance, embarrassment, oppression, or undue burden or expense as described in Indiana Trial Rule 26C. Why would employment information, they're seeking employment information on certain correction officers or law enforcement? Is that what I'm thinking? Is that what they're doing? I don't know. Seeking certain employment information. Employees of the Indiana Department of Corrections. That's what this says to me. All right, so stipulations. 4, the Department of Corrections shall provide to Mr. Allen by counsel the information sought in its narrowed request within 1 business day of the court's order entering a protective order. The Department of Corrections shall provide the information to counsel for Mr. Allen with redactions over whole or partial social security numbers and over home addresses and telephone numbers. So they don't care about that. Like, you don't have to give us that. We'll find these people, but if we need them. But we're allowed this information, and by denying it, you're denying Allen's rights. Yeah. They're seeking employment information for people that work at the Indiana Department of Corrections. Number 5, counsel for Mr. Allen shall share the department's response with the prosecution as prescribed by Indiana Trial Rule 34 C4. Like, he's got to share, I guess, his discovery that if he's going to use it. But all right, so with 1 business day. 6, the materials provided by the department may be used solely for the preparation, trial, and appeal of this action, as well as related settlement negotiations, and for no other purpose, without the written consent of the department. The information contained in the response may be disclosed to any person except in accordance with the terms of this agreement. May not be disclosed. Did I read maybe? I thought I heard maybe. All right, so may not be disclosed to any person in accordance with the terms of this agreement or as otherwise provided by law. All persons in possession of the responsive information agree to exercise reasonable care with regard to the custody, use, or storage of such information. Any use or disclosure of the department's response in violation of the terms of this agreement may subject the disclosing person or party to sanctions. So any disclosure, and you're going to get a motion for sanctions right away. Number 7, all persons subject to the stipulation agree that the information provided by the department may only be accessed or reviewed by the following: A, the court, its personnel, and court reporters; B, counsel of record for any party in this action and their employees who assist counsel counsel of record in this action and are informed of the duties hereunder. Letter C, the parties, including their agents and employees who are assisting or have reason to know of this action. D, experts or consultants employed by the parties or their counsel for purposes of this action, so long as each such expert or consultant agrees to be bound to these terms. And E, other witnesses or persons with the department's consent or by court order. 8, nothing in this agreement restricts a party's ability to disclose the information and materials provided by the department during the course of the trial of this cause. So we can use any of these materials at trial. That's when we can disclose them, but until then, they must remain undisclosed. 9, the parties shall not disseminate the information or materials provided by the department in any pretrial extrajudicial statement by means of public communication, meaning no press releases, no. I mean, Nick McLeland is guilty too of press releases, so he can sit there and, throw shade at the defense all he wants about their press release, but he's done them publicly, like video press releases, which aren't any better. Anyways. All right, so the stipulations, number 10, contained in paragraphs 6 through 9, govern any future document requests submitted to the department by Mr. Allen in this cause. Wherefore, the non-party Department of Correction respectfully requests the court enter a protective order protecting the department's subpoena request. So, yeah. So it seems Richard Allen has a subpoena on the Department of Correction for some employment records, and in order for them to be turned over, they had to agree to all this stuff. I wonder if it's because they're like so afraid they're going to leak something because they think they're so inept, when really it's McLeland and Gull who are not playing fair or with a full deck. All right, so those are the things happening in Indiana, Delphi area today, Carroll County. Yeah, so it's all going to be pretty interesting to see what happens. This was more interesting, I think, that she didn't find them in contempt. And I believe it's just a... I believe the whole thing was just a delay tactic by Nick McLeland and Judge Gull as well, with her throwing them off the case. What happened to my voice? I'm sorry. I can't clear my throat. All right, so since I sound like a frog now, I'm going to let you guys go. Sorry about that. And I will see you guys in the next one. Please hit the like button on your way out, and I will see you in the next one. Take care, guys. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeandcourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.